Okay, you know what, I just noticed.
That's 9.
Okay, tell them who you are, Christy.
I'm for the defense, Ms. Baker, B-A-K-E-R.
I am the court.
I am the witness.
I am for plaintiff, Mr. Green, Green.
Can you guys hear us okay?
Can you hear me?
Can you hear Christy down there?
Mm-hmm.
Okay. Whenever you're ready.
Ma'am, when did you receive the next call that day?
It was only about 20 minutes later I received a page that I had a call.
What exactly do you mean you received a page? Is this your cell phone again?
No, the receptionist telephoned me at my desk.
You don't have a direct line to your office?
Yes, I do, but this call came from the receptionist. There is a central office number, and if you dial that number, then you are talking to the receptionist. If you dial somebody's direct line number, then the call just comes directly to their office.
Who was the call from?
From my husband, Ron Perez.
Is that the defendant in this matter?
Yes, that's correct.
Do you see your husband here in the courtroom today?
He is right there sitting at the table next to his attorney.
The record may reflect the witness has identified the defendant.
Thank you, Your Honor. Did you speak with the defendant that morning on the phone?
Yes, that's correct.
Now, you testified that you are never allowed to have any personal calls while you are working. Does that only just apply to receiving incoming calls on your cell phone, or would it also apply?
No, it doesn't matter where they call. It's just a working thing where the boss doesn't want you talking on the phone when you should be doing your duties.
Yes, I understand.
I mean, it's not like somebody is standing there staring at you or something the minute the phone rings.
That was going to be my next question. When you do receive a personal call, what actually is the procedure for taking that call?
Objection, it's irrelevant what they normally do. It only matters what happened that morning.
Well, I agree, but the objection is overruled at this time. You may answer the question.
You can take the call, but it is just like a working situation. The boss doesn't want you talking on the phone all day while you should be working. That's basically it, really.
Did you have a conversation with your husband sometime that morning?
Yes, that's correct.
What was the basis of the conversation?
He wanted to know why I didn't answer my phone immediately and why I hadn't called him back.
Was it your husband who had called earlier that morning?
Yes, he said he left me a message, and why didn't I answer his message?
What happened then?
He just continued yelling at me and told me that I would be sorry if I didn't answer his calls in the future.
What did you respond to him?
I told him we could always discuss it later, that I was working and couldn't really talk to him anyway.
Did that seem to satisfy him?
He continued to keep yelling louder and got more agitated. I told him I was going to have to really hang up because my supervisor was getting angry with me.
Was that truthful?
No, he wasn't even there yet.
Is this Brenda you are talking about?
No. Brenda is only the office manager. I guess she is one of my bosses in a way. I consider the gentleman who owns the company to be my supervisor, and that's who I was talking about with my husband.
What is his name?
Michael hired me.
What's his full name?
Michael Watson.
How long has Michael been your supervisor?
Oh, he is the gentleman who hired me. I started to work there about 7 years ago, and that's who hired me.
Okay, was Brenda present when you received this particular call from your husband?
Correct, she was working. She wasn't standing next to me, but she was in the same room as I was.
Do you know if she overheard the conversation?
Objection, speculation.
I believe she did.
Objection, move to strike.
Sustained. The answer is stricken. The jury is admonished to disregard the answer.
Thank you, Your Honor.
Did Brenda make any comments to you during this conversation?
No.
So you relayed to your husband that you have to hang up because your boss was upset. What happened then?
He said that he wanted to talk to me and he would come and see me in person if I wasn't going to be talking to him.
What did you do then?
I said I needed to go and that I would speak to him later.
Did you hang up the receiver?
Definitely, I did.
Mrs. Perez, do you follow a set lunch schedule at work?
No, not particularly. I mean, I don't usually go out to lunch anyway. Oftentimes I eat in my office and usually try to get some billing statements finished. It just depends on how busy we are.
That morning, did you have plans with anybody for lunch?
Correct. Brenda and I were going to go out to a new taco place that had just opened up down the street.
What time was your lunch hour that day?
Brenda wanted to leave about 1 o'clock because then any potential crowd would probably be gone at the restaurant. Since we didn't have any time problems, we decided to wait for any crowd to die down.
What time did you leave for lunch?
We left about 1 o'clock.
Is this a restaurant you had to drive to, or is it within walking distance?
We just casually walked over there. It is close enough to walk.
Did something unusual happen at the taco place?
Well, the defendant quickly approached our table and started yelling at me.
Who was present at that time?
It was just me and Brenda at our table, but the place was still kind of crowded.
How many people were in the taco place right then?
Objection, no foundation, speculation.
Sustained.
Do you know how many people were there when you were there?
No, I don't know for sure.
Could you give us an estimate of how many people were present?
Objection, irrelevant.
Overruled.
I would say there were about 20 people there when he came in.
Did you have a conversation with the defendant at the restaurant?
If you want to describe it that way, it was mostly the defendant yelling at me and my telling him to be quiet. I would talk to him later. I asked him to leave us alone and I would telephone him later.
How did he respond to that?
The defendant said he was going to patiently wait for me outside and perhaps I needed to hurry up and finish eating.
Did he subsequently leave the restaurant?
Yes, that's correct.
Did you observe where the defendant went?
No, I couldn't see out into the parking lot from where I was sitting.
Did you ultimately finish your meal, or what happened?
Well, Brenda initially said we should just leave and then
Objection, hearsay.
Sustained.
What did you do after that happened?
we finished our lunch and ultimately returned to the office.
Did you observe the defendant any more that afternoon?
No, I didn't.
He wasn't actually waiting for you in the parking lot as he said?
No, I didn't see him. If he was there, I didn't see him.
Then did you return to work and finish your day there?
Yes, Brenda and I returned back to work and I just had lots to finish up that afternoon. I had a lot of filing to do and I wanted to get it done before I left that afternoon.
Did you have any more conversation or contact with the defendant that day or evening?
No, I didn't hear from him again until the next morning.
Did you have any discussion with Brenda about what had transpired that day?
Objection, hearsay.
Overruled. You may answer yes or no.
Yes, I did.
What was that discussion?
Objection, may we approach sidebar?
All right, on the record, please.
Your Honor, I object to any of this discussion that the question called for on the grounds of hearsay.
That would be sustained. It is hearsay.
I believe it falls in the category of an exception to the hearsay rule. If the victim makes statements right after the event happens, I believe that conversation comes in. Whatever conversation she had with Brenda would be admitted based on that.
What is the time lapse here? I don't think that we have enough information yet.
Well, I don't want it to come out in front of the jury, Your Honor.
Let's release the jury on a break and then we can conduct a hearing with the witness.
Thank you, Your Honor.
Ladies and gentlemen, the attorneys and I have some business to conduct that's not going to require your presence. The jury is on break for 10 minutes. Everyone is ordered to return at that time. Thank you. The record should reflect the jury is no longer present. Do you have any questions for the witness?
Yes, I do. Thank you, Your Honor. Mrs. Perez, you testified that Brenda was present with you at lunch. Is that correct?
Yes, it is.
Was Brenda also present when you had the telephone call at work before lunch?
Correct. She was in the same office I was.
Did she overhear your end of the conversation that morning on the telephone?
Yes, she did. She knows we have really been having trouble for a while. It was not a secret.
Did you have any discussion with her in the office before you left to go to lunch?
Yes, we did.
Your Honor, I believe this hearing was regarding the conversation that was between the witness and Brenda at the restaurant. That was the objection that was given.
Counsel?
Yes, Your Honor, that's correct. But since the objection was the same grounds, I believe I can cover them both.
Objection overruled. Let's continue. Okay, next question, please.
Did you have any discussion in the office before you left for lunch?
Correct.
What did you say to Brenda, and what did Brenda say to you?
Brenda asked me if I wanted her to call anybody or let somebody know what was going on.
How did you reply?
I assured her I was okay, that I was certainly used to it,
Used to what?
to his being very angry for just about everything.
Did you have any other conversation at the office before you went to lunch?
No, that was basically it.
At the restaurant, what was the discussion that you had after the defendant left?
I basically apologized to her for the fight. She said not to worry about her, that she was more concerned about me.
And what did you say?
Nothing other than I was sorry.
And how did Brenda respond to you?
She just believed that we should call the police or have the owner call the police. She didn't want to go outside if he was waiting for me.
Did you ask anybody to call the police for you?
No, I didn't believe it was necessary. I have always just ignored his problems. He has been angry for many years, and I just try to forgive.
Did you have any more discussion with Brenda at the restaurant?
Not really. She just wanted to notify the police, and I said no.
Nothing further.
Do you have any questions while the jury is gone?
Yes, thank you.
Okay.
Were you upset at the time you were talking to Brenda in the restaurant?
Not really. I mean, I was embarrassed that he did that, but there was nothing that I could do.
How much time elapsed before you started talking to Brenda?
I don't understand your question.
At the restaurant, after the defendant left, how much time passed before you started talking with each other?
It was immediately after he left. Brenda said that she thought we should notify somebody and try to get someone to walk us back to work or drive us back.
You feel
Okay, tell who you are.
For the defense, Mr. Tarver, T-A-R-V-E-R.
The court. I'm the witness.
For plaintiff, Mr. Kane, K-A-N-E.
Okay, starts with cross by Mr. Tarver.
Mr. Harris, following the closing of the sale, did you at any time give Mr. or Mrs. Renton a notice of rescission of the agreement?
No, sir.
Now, further, I ask you, isn't it a fact that at no time you gave them any notice of a breach of any condition or warranty?
Through my attorney is the
Do
only.
you know?
I don't. You mean, did I want them to take the house back? Is that it?
No. Did you give them any notice directly, and if so, when, about any breach of condition or the term of the sale of the residence to you?
I am not sure I understand.
Did you tell the Rentons personally, did you talk to them and say you were dissatisfied because of termites or the condition of the house for any reason?
No, Your Honor.
In writing or oral?
No, he did not.
I did not.
You never did?
No, sir.
Now, do you, of your own knowledge, know of any fact that Mr. or Mrs. Renton withheld so far as their personal knowledge of the termite conditions?
I can only relate.
Now, of your own knowledge.
Well, my knowledge was gained through certain things.
Of your knowledge.
Tell him.
I don't want to know what your attorney told you, but what you know.
The state of California informed me of something.
Pardon?
The state of California informed me of something.
You are referring to another proceeding?
It was an inquiry that I made.
We will object to this as being hearsay.
That is not important, I don't think. I agree with counsel. I want to know if you know of your own knowledge of anything that Mr. Renton withheld in the way of information concerning the sale of this house.
I know that he had a termite inspection on it prior to my buying it.
How do you know that?
The state of California gave me the information.
No. Do you know of your own knowledge? Did Mr. Renton tell you?
No, Mr. Renton didn't tell me.
Do you know that Mr. Renton told Mr. Shoei to look for the termites in the front of the window?
I do not know that.
Now, let me ask you further. Is it a fact that you did rely upon, at the time of the sale, on the report of Mr. Shoei and his clearance?
Yes, sir, as related to me by my real estate broker.
Is it a fact that you relied upon this report and the clearance?
Yes, sir.
As stating the condition of the house insofar as the termites are concerned?
Yes, sir, right.
Mr. Harris, I want to touch on one question here first. You stated on February 15, 1966, that you had a conversation with Mr. Renton,
That's correct.
and you made a memorandum of the conversation a short time thereafter.
That's right.
And you recall saying in this memorandum that, quote, Mr. Renton later obtained another buyer, but without telling me about the first inspection, stated that he had been told by someone that there were drywood termites under the house, unquote. Is that true?
That's true if I wrote it down there, yes.
So he did tell you there were drywood termites under the house?
Excuse me, you are referring to February 15, 19?
No, at the time before the inspection.
No, this note refers to the meeting in my office on February 15.
That is 1966?
Right.
Well, the language again says, Mr. Renton later obtained another buyer, but without telling me about the first inspection, stated that he had been told by someone that there were drywood termites under the house. Now, Mr. Harris, how long have you been in the termite business?
Since April 1933.
When were you licensed?
April 1933.
Are you licensed at the present time?
Yes.
That is immaterial.
He says he is.
I know, but it is immaterial.
It is going to open up some questions, Your Honor, which I would like to approach the bench on later.
Wait until it arises.
Are you licensed at the present time?
Yes,
And have you been licensed continuously from the date of the report rendered in this controversy and in the present time?
Excuse me, that is completely immaterial if the court please. The question is, what were the facts and circumstances at the time of this incident? Counsel knows this very well.
Well, I know the discussion of the case that is behind all this.
I am not going to touch on anything objectionable.
I think you already have.
I think I'm entitled to know if he's been licensed continuously from the date of this report.
What relevancy would that have?
Only as to its weight. You may answer that question.
I have a license. I always have had one. That is since April 1933.
Are you licensed continuously from the date of this report?
Yes,
Has your license ever been revoked or surrendered?
Excuse me, now, Your Honor, I am going to move for a mistrial. Cite counsel for misconduct. He has full knowledge of this that I will be prepared to put on the record, Your Honor, and I have to move for a mistrial at this time. That is misconduct.
It will be denied. Ladies and gentlemen, I will say, assuming there is an objection to a question, I will sustain it. The fact before you is, at the time of this incident, sometime in 1964, that Mr. Harris was a licensed operating pest exterminator. You don't mind if I use that word?
that's a good word.
I can't think of another word.
We use control, structural, pest controller, pest control.
So that I will instruct you to disregard any statements that have been made in court by counsel. Again, I say this is something that is difficult for a jury to do because once you hear things, even though the court tells you to disregard it and strike it from your memory as if you never heard it, all I can do is say that you tried to do that. You never heard it.
Mr. Harris, going back to the time when you first made your contact with Mr. Renton, some 10 years prior to 1965, you've testified you did a considerable job for him for subterranean termites, drywood termites, fungus, which amounted to approximately $2,000 more or less.
I testified to that, yes.
And you testified there were 2 carpenters who were on the job and that they were on the premises for perhaps 2 weeks.
I think there was 2 or 3 carpenters for 2 or 3 weeks, yes.
And that they, among other things, tore away some of the stucco and replaced some of the wood members of the frame of the house, treated it. Is that true? Is that a fact?
We tore away considerable, not some. It was considerable all the way around the house.
Drawing your attention to that, what did you do then after you tore the stucco away from the side of the house?
Then we removed the rotted or infested material, wood, 2x4s, whatever the case may be, and you take them away.
To the dumps, and you treat the material or replace it?
Completely replace it with new material,
And you treat it at all in addition to the replacement?
yes.
And you recall, did you do that in this case?
I am sure I must have.
Now, you recall in this case whether you found any beetles in the attic?
There were none.
You recall whether there were any drywood termites in the house at any location?
I don't recall where they were found, but I think it was around the front porch.
Make a note, sir. We will take it up this afternoon at 2 o'clock. We will adjourn and have our luncheon until 2 p.m. and remember the admonitions of the court. Jury is present. Where were we?
Mr. Tarver is examining Mr. Harris.
All right, continue.
Mr. Harris, have you ever been convicted of a felony?
Yes.
State the time and the court and the felony convicted for.
1959, I think it was in June, I helped somebody obtain an abortion.
Which court was that in?
That is immaterial if the court please.
I think you are limited to the nature of the offense charged, the circumstances.
Would you state the circumstances?
I think he has. That is it. I think that limits it.
That is about it.
1959, in June thereabouts?
That's been asked and answered.
Yes.
Object on that ground.
May I say, ladies and gentlemen, that this question is asked. You will be instructed as how you determine the credibility of witnesses. I assume under these 70 or 80 instructions, one of the attorneys has put that in, and that is the credibility of a witness. One of the factors upon which you make your determination is a conviction of a felony. That is the only purpose of this.
We were talking about the procedure that you followed when you inspected the Renton premises and subsequently the work some 10 years prior to the May 1965 inspection work and clearance. And if you will, tell us step by step, as well as you can recall, what you did during your inspection at that time.
I think I have described it already.
Would you describe it step by step?
It has been asked and answered.
You object on that ground.
I will object on that ground in the interest of time.
Have you gone over this before, sir?
I beg your pardon?
Did you go over this morning, the same question he just asked?
Yes, we went through it this morning. He asked me and I made a circumference of the building and I described it.
All right, sustained.
Now, did you go into the attic?
No,
Did you go through the interior of the house?
only partially.
And what did you look for when you went through the interior of the house?
I didn't look for anything in particular. I was talking to Mr. Renton, I believe,
Where do the drywood termites do their damage?
in the wood.
Which portion of the house? On the ground, in the wall, in the attic?
In the wood they are in, wherever it is.
They may infest the wood throughout or in any location.
Any piece of wood they are in, wherever it is, that is the piece of wood they damage.
When you examined the premises on that occasion, some 10 years prior to 1965, did you find any drywood termite damage?
I found some, I think, in the front porch.
Now, I believe you testified that there was substantial subterranean termite damage around the circumference of the house at various heights. Is that true?
Yes.
Did you examine the back stairs?
When?
Anytime. We were talking about...
10 years prior?
Yes, the first.
I presume we must have.
And the sills, the mud sills?
Yes,
And the wood areas under the windows?
yes.
Did you crawl under the house to examine the area under the house?
You mean 10 years before 1965?
Yes.
Yes.
Do you recall whether you used a flashlight or not?
That is the only way you can see.
Do you recall on that occasion in your remedial work, in your repair work, strike that, in your remedial work, whether you sprayed any portion of the underside of the house with copper solution?
I don't recall exactly what we used. We either used copper or we used creosote or some arsenic compound.
You recall Mr. Renton expressly asking what that was for?
No,
You don't recall that he did,
I don't recall any conversation.
that he did or did not?
I don't know.
Did you talk to him periodically during the inspection and repair?
You are mixing two things together.
Did you talk to him periodically during the inspection,
About inspection, yes,
during the repair,
yes,
and during the administration of any solution for remedial effects?
yes.
So you could have talked about the copper solution.
We were using it. I probably talked to him about it.
Now, 10 years ago, a $2,000 job would be substantial, wouldn't it?
That is a substantial job, yes.
Even more so 10 years prior to 1965. That would be 1955.
Well, I have no way of comparing.
Would the cost of the repair and remedial work have increased between the year 1955 and the year 1965?
Oh, yes. Plaintiff's attorney is Mr. Whitman, W-H-I-T-M-A-N. Defense attorney is Ms. Rest, R-E-S-T. Question by plaintiff's attorney. At the time that you turned around, you were able to see the clothing he was wearing. All that I know is that it was dark. And why were you only able to see that it was dark clothing? If it was light, I would have noticed it. So when you turned around in front of your apartment, you told us already that you had seen him for a minute. Is that correct? Yes. And approximately how far was your face away from his face? About 12 inches, 1 foot. Now, you were sitting on the driver's side, is that correct? No, I was on the passenger side. Passenger side. While you were sitting on the passenger side, what illumination, if any, was shining on the defendant's face? The light from my kitchen window, the street light that's over here, the light along the fence. Now, those lights that are along the fence, are those white colored lights, or what color are they? They're white lights, but they're in a box, and it's kind of a gold tinted glass along the fence and above my front door. As well as being above your front door, are they above the doors of all the apartments along there? Yes. How many apartments are there that go from the front to the back? 5, so there's 10 lights altogether along the driveway. When you were doing the composite with Sergeant McGrath, was he sketching this out, or was he using some other device? He had composites of different eyes, different chins, different noses, different hair, and I tried to pick out the best that I could from the selection he had. So if you're looking at a series of chins, you'd have to pick one of those out. Is that correct? Yes. And if you're looking at eyes, you'd have to pick one of the sets of eyes out. Yes. And that would be the same for hair, cheeks, etc., all the features, everything. And then he put these things together? Yes. Showing you Plaintiff's Exhibit number 18. For the record, it's a composite by Sergeant McGrath. Showing you Plaintiff's Exhibit 18. Could you examine 18? Yes. Now, what does 18 represent? Well, it represents the best I could do with the selection he had. And this is the composite that we put together. Showing you Plaintiff's Exhibit 19. What does 19 represent? Well, that's what I actually saw. What was that with the bandana on his face? Okay, I see. Covering up part of his nose, mouth, and chin when I initially turned around and looked at him. Now, when you saw from the tip of his nose down, that's when you saw from a profile. Is that correct? Yes, yes. What type of material was it that was consisting of the bandana, if you know? It was a beige, thin cotton material. Now, the material that you eventually were tied up with, what type of material was that? That was a light blue, sort of a polyester nylon type material. Showing you Plaintiff's Exhibit number 10, a couple photographs. What does Exhibit 10 show? That's a picture of Sherry Hunter. And is there anything on her wrists? Yes, that's what he tied us up with her up with. Is there any doubt in your mind that the person, the defendant, Todd Grayson, is the person that attacked you, robbed you, and raped you? There is no doubt in my mind. I will never forget his face. I have no further questions. All right, cross-examination. Thank you. Does the court mind if I use the stand here? No, I don't mind at all. Thank you. Ms. Wade, you say there's no doubt in your mind that you will never forget his face. Let me just, as a point of clarification, you at no time ever saw this person straight on, face to face. Is that correct? I did see him face to face, but with the bandana on, covering his nose, mouth, and chin. And all the other times were profiles. Is that correct? Yes. And in this composite that the district attorney has brought out, the one with the bandana on, that is the closest that you can come to in terms of a face-to-face. Is that correct? Correct. You don't have any idea what was below his face, below the bandana on the left side of his face. Do you? No. Now, you testified that, do you remember testifying at the preliminary hearing in November? Yes. And that's when you were called to court and you testified. And at that time, Mr. Grayson was sitting at the defense table at that